So, without any further ado, I'd like to begin the first session of today and introduce you to our keynote speaker, Ms. Frances Raday, who is Professor of Law and Director of the Concord Research Centre for Integration and International Law in Israel at Coleman. She's a Special Rapporteur of the UN Human Rights Council Working Group on Discrimination Against Women and a former expert member of the Committee on the Elimination of Discrimination Against Women, the CEDAW Committee, with whom many of you will be very familiar. She's a human rights litigator and has acted as lead counsel in numerous cutting-edge cases involving women's right to equality in political, economic and religious contexts, involving issues such as employees' rights and transition situation, migration, transfer of corporations, transnational patents and military occupation. An incredibly impressive breadth of human rights expertise. She is the Professor Emerita, Hebrew University Lieberman Chair for Labour Law, Honorary Professor, University College London, and Dr. Aranis at the University of Copenhagen, author of numerous academic books and articles in international human rights law, on religion and human rights, labour law, and feminist legal theory. So I'd like to introduce you to Ms. Frances Raday.
Thank you very much indeed, Liam, for that very generous introduction. And for picking me up at the airport last night. I did come kind of a quarter of a way across the world to be with you today, because I think that I come with a message, a very mixed message, about what's going on in the UN system and globally regarding women's human rights. Could we possibly put up my PowerPoint?
Yes.
Thank you. Because the context of the discussion about abortion is a context of backlash. And I have been part of the fight against that backlash at the level of the Human Rights Council. You know, the Human Rights Council has its political arm, the 47 countries that sit in rotation on the council, and the experts, the special procedure, the independent experts. And there is a fight going on. And the fight is absolutely relevant to the issue of women's sexual and reproductive rights. Because the Human Rights Council resolutions by the countries in its political arm over the last nearly decade have been regressive. They have been focused on trying to restore traditional values. We can talk about religion. The countries leading the traditional values lobby are Russia, resting on the Russian Orthodox Church, and the Organization of Islamic Communities, also a religiously based organization. And these countries have been pushing an agenda for traditional values, preventing defamation of religion, and most recently, protection of the family. Protection of the family. I was already on the Working Group for Discrimination Against Women when I saw that the Protection of the Family resolution did not include a reference to women's right to equality in the family, recognized since 1948 in the Universal Declaration of Human Rights. And I protested, and I led a rebellion of the independent experts against the Council to say you cannot have a resolution on protection of the family without guaranteeing women's right to equality in the family. We only partially succeeded. Later resolutions have talked about the importance of women's equality in the family, not their right to equality in the family. So that is the context in which I find it very important for you, the civil rights and human rights activists, to be aware of what we're all up against. Well, as regards women's, it's not up. Okay, so I want to go through, I'll go through several headings. I want to go through very quickly because I want to show the whole picture, but I'll be happy to answer questions afterwards. So firstly, the context of rights which have been established and under which we're discussing women's sexual and reproductive rights are women's right to equality, to dignity, to autonomy, to bodily integrity, to respect for private life, to the highest attainable standard of health, including sexual and reproductive health, without discrimination. The right to health is without discrimination, and termination of pregnancy is something that only women need. So it's a differential right Equality means differential treatment for women in this respect, as well as the right to freedom from torture and cruel, inhuman and degrading treatment. All those rights are involved in the question of women's facing the access to termination of pregnancy. This is primarily a women's issue. It's her decision. It may shape, and usually does shape, her whole future personal life and family life, and has a crucial impact on her enjoyment of all the other rights, whether it be to education for girls, whether it to be an economic activity for women, whether it be family situations. It impacts every aspect of a woman's life. But we're not only talking about women's rights, we're talking also about utilitarian arguments. The World Health Organization has shown, not a feminist organization, health organization, has shown that in countries where induced termination of pregnancy is restricted by law, safe termination of pregnancy is a privilege of the rich, while women with limited resources have little choice but to resort to unsafe providers and practices. So this results in severe economic discrimination, discrimination against poor women. There's a lot of hypocrisy here because, as we saw with senators in the US Senate who have procured abortions for their mistresses and then go out and fight against abortion for women, what they're saying is if you're rich, you can have one. If you're poor, you can't. And we have seen also, which I'll come back to, that the World Health Organization has shown that actually prohibition of abortion does not stop termination of pregnancy in terms of the incidence of procedures in the countries concerned. So it's not just some kind of luxury argument about women's choices. It goes much further. Accordingly, knowing that this is the situation, the working group called, and this is the first time it's been called for openly in the UN system, for allowing women to terminate a pregnancy on request during the first trimester. It's not, of course, new. We've had since Roe versus Wade in 1973. We have had the idea, and in a number of countries, it's good practice in a number of countries to allow women to choose during the first trimester. And despite the propaganda by pro-life, as they call it, but I think it's anti-choice organizations, that this is killing a baby. In fact, at that stage, it's a small collection of non-individualized cells from which both the embryo and the placenta will develop. And so the pictures, the inflated pictures of embryos that look like babies are really a propaganda tool to prevent women's interests being put first. In international human rights law, the right to life and all other human rights under the human rights treaties are accorded at birth. And this was intentional. In the Universal Declaration of Human Rights in 1948, it was held all human beings are born free and equal in dignity and rights. Now, in the current discourse, this is ignored, and instead of putting women's human rights at the center of policy considerations, this is obfuscated by rhetoric and political power behind the argument that there's a symmetrical balance between the rights of life, the rights to life of two entities, the woman and the unborn. This is not well-founded in international human rights law. I will go further. It has been pointed out that under the Children's Convention, it's pointed out that in the preamble, it does say that the rights of the child, that there is to be protection of the child before and after birth, but it's protection, it's not rights. Under the articles of the Children's Convention, rights are awarded to children, and children are registered at children at birth under the Children's Rights Convention. The claim that the entitlement to human rights begins at conception was propounded and has been propounded in some belief systems, notably the Catholic and evangelical churches. It is not accepted by all religious systems. It is not accepted by all the denominations of Christianity. When the Pope introduced this, that was the impetus for the anti-abortion laws that are the basis of our discussion today. Previous to that, there hadn't been prohibition of abortion. Nevertheless, between 1950 and 1985, almost all developed countries liberalized their abortion laws, recognizing that if there is a belief among some churches, some denominations, some individuals, that life begins at conception, they are entitled to that belief. They cannot impose it on others who do not share that belief. It's a belief. It's not a scientific fact. It's a belief. Now, so then, resting on that there is a distinction between the value of life as such. I'm not here to dismiss the importance or the beauty of pregnancy, of gestation, of birth, of future generations. This is not what I'm trying to do here. But there is a distinction between the value of life as such and a legal right to life and all the other human rights. The true parameters of contestation are between the rights of a born person who is the subject and repository of international human rights, that is, the woman, and any societal interest that there may be in the process of gestation of a possible future person. It is not a contestation between two symmetrical right holders. Most notably, the Colombian Constitutional Court, basing its decision on women's right to health, life, and equality, determined that the legal right to life is limited to born human beings and drew the distinction between the value of life, including fetal life, and a legal right to life. You do not have to be some kind of hard-hearted monster to realize that this is the true question. This is the true question. In this context, we have several human rights bodies called for an end to the prosecutions and punishment of women or medical service providers for murder or manslaughter for their involvement with termination of a pregnancy. You may not know it, but in El Salvador, and it's not the only country in the world, women are being put on trial for miscarriages which they cannot prove were not induced. And the sentences are, may I let you guess? Not 2 years, not 5 years, 30 to 40 years, up to a lifetime in prison. And they're leaving small children at home. We're talking about hard hearts. They're leaving small children at home whom they will not see until they're in their middle age. So we have said you can't have murder or manslaughter except of a born person. A fetus is not a born person. The blanket prohibition of abortion, which I'm calling blanket including prohibition of abortion where there is a risk to the woman's life. For example, now the Dominican Republic just refused to amend, by a large majority, refused to amend its abortion law, which prevents abortion, prohibits abortion, even where the woman's life is at risk. We say that that is a form of femicide. It's a form of femicide authorized and even dictated by the state. The idea that you make a woman die rather than give her a procedure which will allow her to live is femicide. The next issue is decriminalization of abortion, of the termination of a pregnancy in general. And I really do prefer the term termination of a pregnancy, because abortion has become a very weighted kind of name. Well, human rights mechanisms started from a rather hesitant approach to the liberalization of termination of pregnancy, only requesting that states consider changing their laws on termination of pregnancy so to at least allow abortion in the exceptional cases of risk to the woman's life or health, rape, or severely impaired fetus. However, in the past few years, not very long ago it started, a number of human rights mechanisms, including the Special Rapporteur on Health, our working group, the Economics and Social Rights Committee, the CEDAW Committee, and the Special Rapporteur most recently on extrajudicial, summary or arbitrary executions, have moved to requiring decriminalization as a general matter and call for an end to penalizing women and health service providers for terminating a pregnancy. In General Comment 35 of CEDAW on gender-based violence, the CEDAW Committee determined that criminalization of abortion is a form of gender-based violence that, depending on the circumstances, may amount to torture or cruel, inhuman, or degrading treatment. The decriminalization approach is well-founded not only on women's human rights, but, as I've already said, also on utilitarian grounds. And I return and emphasize again that the World Health Organization data has clearly demonstrated that there's no evidence to suggest that restrictive laws lower the rate of abortion incidence. What it does is increase women's mortality and morbidity. According to a 2017 World Health Organization study, in countries where abortion is completely banned or allowed only to save the woman's life or physical health, only 1 in 4 abortions was safe. 1 in 4. 3/4 of abortions were unsafe. 3 out of 4 women were risking their lives in order to terminate a pregnancy. Whereas in countries where abortion is legal, on broader grounds than that, nearly 9 out of 10 abortions were safe for the woman. Criminalizing termination of pregnancy does not reduce women's resort to abortion procedures. It's likely to increase the number of women seeking clandestine and unsafe solutions. There are approximately 25 million unsafe terminations of pregnancy annually, resulting in 47,000 deaths. And nobody has counted the number of cases of morbidity, of women's ill health, resulting from unsafe abortions. Behind these figures is desperation. Desperation of women who find themselves with unwanted pregnancies, women and girls who find themselves with unwanted pregnancies and the prospect of unsustainable motherhood. So that brings us to what after the first trimester. We've said already that we feel that the first trimester there should be no question, there should be women's choice between her and her medical provider. What after the first trimester? The human rights mechanisms have called in parallel, on one hand, for decriminalization of abortion. But on the other hand, they continue to call for legalization of abortion, variously in cases in which the life or health, including mental health, of the pregnant woman is threatened, in cases of rape, incest, and fatal or severe or fatal fetal impairment. And it varies, you know, the formulation varies from one mechanism to another, but that's roughly the exceptional cases after the end of the first trimester. Where access to termination of pregnancy is denied in these circumstances, expert international human rights mechanisms and entities have repeatedly concluded that in some situations, failure to provide women to access to legal and safe abortion in these circumstances, in these exceptional circumstances, may amount to torture or cruel, inhuman and degrading treatment, and a violation of their right to life, as in the Human Rights Committee decisions in Whelan versus Ireland, well known to you, and in Mellett versus Ireland, and VDA versus Argentina, and in the CEDAW Committee's decision in KL versus Peru. But we're still there within this framework of the extreme exceptional cases. The requirement of grounds, in general, after the first trimester may provide a balance between the human rights of the pregnant woman or child or girl and a societal interest in discouraging termination where the pregnancy is more advanced, which involves a more complex medical procedure for the woman and a more fully developed fetus. Though there should never be criminalization, and that's we've learned already from the human rights mechanisms, there should never be criminalization of the termination of pregnancy, termination after the first trimester. This is what the working group is trying to work out of this, may be subject to the need to make room for greater societal interest in the process of gestation and may hence be regulated within the health system as regards procedures for accessing medical services. It's a more complex decision, that's all, not criminal. In any case, where objective grounds are required, they should be expansive. The existing list is eclectic and narrow and gives a solution only to a few distinct reasons amongst the many legal, cultural, social or economic reasons which are just as compelling, which may force women to seek termination of pregnancy. Examples include pregnancies in situations of domestic violence, in situations of war, child marriage, refugee status, extreme poverty, large family that cannot be supported, etc., etc. Our group has suggested that in the vast majority of cases, women only seek termination of pregnancy when they're forced to do so by oppressive legal, cultural, social, or economic circumstances, and hence there should be a subjective as well as an objective test of good reason, relying on the equal and indeed superior ability of women to make a judgment call regarding their reasons for not being able to continue the pregnancy. This is a decision which women do not take lightly. Human rights mechanisms, including the working group and the commission, the Committee for the Convention on the Rights of the Child, have unambiguously called for legalizing the termination of pregnancy of children under the age of 18. We began this when we went to Peru and to Chile, and we found that teenage pregnancy is considered one of the most severe social and family problems. It is so widespread, little girls raped on their way to school and unable to access abortion. And in fact, in Paraguay, is the famous case of a 10-year-old girl who was raped by her stepfather. The stepfather fled. The mother complained to the police and wanted the child to have an abortion. The state and the church refused to let the 10-year-old have an abortion. They said she could have the pregnancy and carry the pregnancy to term without danger to her life, and because there is a danger to life exception. And we intervened. Unfortunately, with no success. We weren't the only ones who intervened, and that child was forced to have a baby. And the mother sent us a video afterwards. Well, she didn't make the video. Somebody sent a video of the mother, and she was weeping. And she said, "My 10-year-old daughter, I wake her up at 3 o'clock in the morning to breastfeed." They're a very poor family. I wake her up at 3 o'clock in the morning to breastfeed instead of sleeping so she can go to school and become educated and have a life. My daughter's life is in shatters, in tatters, is ruined. Can you imagine waking up a 10-year-old child to breastfeed at 3 in the morning? The Committee on the Rights of the Child has urged states to decriminalize abortion, to ensure that girls have access to safe abortion and post-abortion services, and to review legislation with a view to guaranteeing the best interests of pregnant adolescents and ensure that their views are always heard and respected in abortion-related decisions. There you are. The Convention on the Rights, the Committee on the Convention on the Rights of the Child has also said this is a subjective. You've got to listen to the good faith need of the woman or girl who is pregnant. Well, this is the move forward. But there are also some restrictive and regressive moves in the human rights system beyond the general political moves. And here I'm talking about the human rights mechanisms themselves. I've talked about the backlash amongst the political branch in the Human Rights Council and in the General Assembly, incidentally. But now I'm talking about independent human rights experts who have moved to a different track. And the first is the Committee for the Rights of Persons with Disability. It's called, for example, in its concluding observations to the United Kingdom, to withdraw the right to terminate a pregnancy on grounds of fetal impairment. And they quote, women's rights to reproductive and sexual autonomy should be respected without legalizing selective abortions on grounds of fetus deficiency. Well, this is an internal contradiction. Because if you really want to respect women's reproductive and sexual autonomy, you cannot do it while refusing to allow them to select to have a termination of pregnancy on grounds of fetal impairment, severe impairment, or fatal impairment. And some of the most tragic cases actually have been those cases. And there are two reasons why this can't be the case. Firstly, there are still many countries which do not allow women to choose an abortion without grounds. And secondly, mostly these kind of problems are discovered after the first trimester. So if the CRPD's recommendations were to be accepted, it would actually severely restrict women's right to reproductive and sexual autonomy. I do want to point out that based on my previous argument that the right to life begins at birth and the right to personhood begins at birth, there seems to be some confusion here. I think that there is nothing more important than respecting, protecting and fulfilling the rights of persons with disabilities after they are born. That does not mean that there is a right to be born as a person with a disability any more than there is a right to be born at all. So I think this is based on some, for me, tragically wrong perception that choosing not to have a baby that is going to suffer from severe disabilities means that you discriminate against persons who have, either from birth or from accident or from old age. Most of us end up with severe disabilities. This is not an attempt, this is not even a hint at discriminating against persons with severe disabilities. The Human Rights Committee has an extremely disappointing draft of its general comment on the right to life. It calls for decriminalisation of abortion, but not in a general way, the way other human rights mechanisms and entities have been calling for decriminalisation. It appears to qualify it by saying, giving restrictive examples of the obligation to decriminalise. Criminal sanctions which are expected to significantly increase resort to unsafe abortion. Leaving this as a very vague thing, not a strong statement that termination of pregnancy should never be criminalised. And strangely, they refer to needing to stop the criminalising of pregnancies by unmarried women, which is a kind of non sequitur, I think, in the middle of this debate. And while they do say that regulation must not violate the right to life of a pregnant woman or her other rights under the covenant, it then gives a restrictive list of grounds back to threat to life of the woman. It doesn't even say health, or causing pain or suffering in violation of the torture provisions of Article 7, even more extreme, and to situations in which carrying a pregnancy to term would cause the woman substantial pain or suffering, most notably where the pregnancy is the result of rape or incest, or where the fetus suffers from fatal impairment. So we see the narrowing back to the pre-last decade kind of formulations, minimalistic formulations of women's access to termination of pregnancy. The working group, we put in a very strong paper position paper to the Human Rights Committee, but from inside information I have, I understand that there are some extremely conservative, religiously based members of the committee who are fighting very strongly for a restrictive formulation. Well, the last thing, and I think I'm going to say it very, very briefly because I don't want to take up more than this, I said 45, so here we go. The right of the pregnant woman to access termination of pregnancy should be autonomous, affordable, and effective. We called in our annual report on women's health, and also in our position paper on termination of pregnancy. We called on states to ensure that the access to healthcare, including reproductive healthcare, should be autonomous, affordable, and effective. And this necessitates a series of measures with regard to termination of pregnancy. Firstly, you must invalidate conditioning of women's and girls' access to healthcare on third-party authorization. In our country visit to Spain, we found that Spain, which is part of the EU and was not really trying to prohibit abortion, was trying to find ways of limiting abortion. So they were saying that girls over the age of 16 and under the age of 18 must seek the approval of both parents. And we said this is a very bad move. You cannot condition the girls' access to abortion. You could appoint a public health commissioner. You cannot. This pregnancy might be the result of incest. It might be there might be in situations in which the girl would be exposed to danger to her life and safety if she went back to her family on the issue. You can't. And then we found that even the human rights organizations who agreed, who were also opposing this measure, had not thought about the situation of girls under the age of 16. And it seemed to be obvious to everybody that girls under the age of 16 needed the approval of both parents. And we said, no, you must appoint a health official or a social official to do this. You must not send these little girls back to their families unless they want to go to their families. The second, you must provide training to health providers, including on gender equality, non-discrimination, respect for women's rights and dignity. Women are exposed to great indignities in everything to do with their sexual and reproductive health in many healthcare systems. They are treated with contempt and some kind of misogyny in many situations, including even physical violence to women who are in birthing procedures and so on, and also clearly in termination of pregnancy. They must provide, and this is very important and exists in few places, non-discriminatory health insurance coverage for women without surcharges for coverage of their reproductive health, and they must exercise due diligence over the diverse private actors and corporate and individual health providers to make sure that they also do not discriminate against women because of their reproductive health needs, including termination of pregnancy. They must include contraception of choice and termination of pregnancy in universal health care measures, or subsidized provision of these treatments and medicines to ensure that they're affordable. One of the things that the World Health Organization pointed out is that access to affordable contraceptives is the best way of avoiding termination of pregnancy. It's so obvious. Must restrict conscientious objection to the direct provider of the medical intervention, not to health insurance companies and employers, as in the Holly Lobby case in the United States, and must allow conscientious objection only where an alternative can be found for the patient, for the woman to access treatment within the time needed for timely performance of the procedure, because this is a sticking point for many women. They must provide age-appropriate, comprehensive and inclusive sexuality education from schools upwards. Now then, there is backlash and regression. We've seen it in the political branch of the Human Rights Council. We've seen it to an extent, I think, in the independent experts, signs of some regression. We have a situation where 25% of the world's population live in countries with highly restrictive abortion laws. There are politicized religious conservative movements active within the human rights mechanisms and in various countries. In Chile, it took years for a female president who'd been the head of UN Women to manage to get a minimal termination of pregnancy law through the parliament in Chile this year. It's taken years to do it, voting against it all the time, even to allow abortion in case of risk to life. So there are attempts to turn the clock back and introduce restrictive abortion laws and contraception coverage in the United States, Poland, the Philippines, Sierra Leone, probably in Hungary, where the constitution provides that conception, that life begins at conception. There's a danger there. Eastern Europe, you're having a revival of politicization of Catholic dogma on this issue. The courts, some courts have had a very good record. The Canadian court, the original Roe versus Wade decision of the Supreme Court, the Columbia Constitutional Court, some have not. The German Constitutional Court had a bad decision, and the UK Supreme Court disappointed me enormously, not only its decision not to allow the funding of abortions for Irish women who came, Northern Irish women who came over to England for an abortion, but in the majority opinion which said this was a democratic decision of the Irish Parliament. Has everybody forgotten that human rights restrain majoritarian politics? They're there to restrain majoritarian politics. Women's human rights are not up for the vote. And I was very disappointed to see any of the judges, and it was the majority judges in the UK Supreme Court, express an opinion that this was a democratic process. In conclusion, we have concluded that much of the preventable ill health of women, including maternal mortality and morbidity, can be attributed to the instrumentalization and politicization of women's bodies. Insisting on the right of life, the right to life of fetuses, and equating this right to the right of a born woman or girl to her life, her health, her autonomy, and her entire personhood by criminalizing termination of pregnancy is one of the most damaging ways of instrumentalizing and politicizing women's bodies and lives, subjecting them to risks to life or health, and depriving them of autonomy in decision-making regarding their own lives and bodies. So I wish you all luck in all corners of the world.